Okay, now officially I'm done, but I'm not done. You only get one of those. Right? I'm going to really strongly advise you ladies to go to counseling. Right now, Mr. King.
Okay, I think
Did we lose her?
She's on her way, Judge.
Okay, that's fine. That's fine. That's fine. Mr. Duncan on Mazdi.
Judge Marie Duncan, on behalf of Ms. Mosby, please give me.
Good morning.
Judge, it's been agreed with the prosecutor that the felony would be dismissed. Ms. Mosby would be 1 to 1,000, 1.1. The victim, which is the mother's, there's a sentence or there's recommendation too, Your Honor, that my client do anger management. And I don't really believe we need much more. The parties have talked, we reconciled with what the problem was. My client went in and fixed the door that was damaged, so that's been done. I do have an anger management class I've been sending my clients to. It's an 8-hour online class. Most of the courts accept it.
Yeah, where's it at?
I don't have it in front of me.
Give me that information because I'd like to put that in our arsenal.
Okay, then I will.
Yeah.
But I've had quite a few clients do it just because it's doable in 1 week. Otherwise, I'm ready.
Good. Good. All right. You understand your rights and options after discussing those with Mr. Duncan? You understand the possible penalty for the charge? Understanding all of that, are you pleading guilty? Freely and voluntarily pleading guilty? Would you void error?
Ms. Mosby, on August 14, 2024, were you in the township of Van Buren County, Wayne State, Michigan?
Yes.
And were you at your mother's residence at 9855 Andover Drive in Van Buren Township? And at that time, did you destroy or damage any property in your mother's residence? What did you damage?
Storm.
And was that intentional? And has that door been repaired? And was it repaired by you at your cost?
By us, yes.
And what was the cost on that?
$500.
Judge satisfied?
I'm satisfied if you are.
I am.
I'll accept the plea. I'll dismiss the felony matter. Mom, would you state your name for me?
Name is Mary Goss.
Picking her up.
Yeah.
Okay, you can stay there. You can stay there. You're nice and loud. Is there anything you want me to know before I set the terms of sentence?
Well, sir.
Okay, that's all I wanted. All right. What else should I know?
Well, Judge, she works full time. I'm sure it's Ford, correct? She works full time. She's had some issues with her mother. They're trying to work through them. There was not a no contact. That's what allowed her to go and take care of the door.
Right, right.
I don't think we need reporting probation. I think if we put her on 771.1 and she.
No priors? No priors?
No.
Yeah, go ahead.
So I'm asking the court to just have her do the anger management and obviously tell her that she can't get into any more trouble during this time. And finding costs.
Right. Okay. Anything else you want me to consider? All right, I'll delay sentence for 12 months, stay out of trouble, no new criminal offenses, anger management, stay out of trouble, $500 court costs, that's done. As long as all that happens, at the end of 12 months, we dismiss. Understood? Can you pay the 500 today? You sure? Or I'll give you a due date. What do you want? How much? All right. Okay, now officially I'm done, but I'm not done.
Give me the phone for you.
You only get one of those. Right? I'm going to really strongly advise you ladies to go to counseling.
Yeah.
Great. 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 You just made my tail wag. Yeah.
I don't want to think of her record. I would like it. The whole thing would be just.
Yeah. No, unfortunately, sometimes the system takes a life of its own. Yeah, but this gives her the option to get it off her record. Now, and I'm sure you've explained, the arrest will always be there. The plea will always be in the system, but the conviction will be dismissed. So anybody in the system knows what happened. But if you go to get a job somewhere and they look at your criminal history, there's no conviction at that point. Okay?
After 12 months, it's wrapped up, right? If you don't.
The conviction goes away. Right. But if she applies to the FBI, they're going to know about all this. because they have access to records that your employers don't. Understood?
Thank you, Judge.
All right, good luck.
Judge, is Buddy's transportation file here yet?
Are we ready on Staples? Your appearance, counsel.
Good morning, Your Honor. Paul Stavlin, appearing on behalf of Staples approach.
Good morning. Go ahead, counsel.
Your Honor, I am to the prosecutor, Judge, we resolve this matter. You should have a form in your file.
I do.
Ms. Staples is going to plead guilty to the offense of operating rules that impaired in exchange for prosecution to dismiss the original count. I've advised what rights would be in regard to a trial. She's waiting all those things.
That's all true? Okay. And you understand what the possible penalty is for the added charge? All right. Understanding all of that, you're pleading guilty freely and voluntarily?
Yes.
Counsel, would you voir dire?
Ms. Staples, on March 30th, 2024, were you operating one vehicle?
Yes.
And was it on I-94? Okay, that was in City of Climax, correct?
Correct.
And prior to driving, did you consume alcohol?
Yes.
And you had your ability, because of alcohol, ability to operate a motor vehicle been impaired to the point where it was physical to another person.
Yes.
You satisfied, counsel? So am I. I'll accept the plea and dismiss both original count 1 and 2. She got priors?
No. I indicate to the court that Ms. Staples also has, I've had her evaluated by Raj Mehta, who's a social worker.
Good.
Who put her through a number of tests. And his conclusion, with respect to the case, Judge, was that she appears to have no significant, no apparent problem in regard to drinking. And he concludes that her likelihood of reoffending is very low because of her family support, because of her, she also did complete with Mr. Mehta the level 1, what he calls level 1 high BAC.
Well, tell me about that.
So I just had this meeting and we talked about you.
The level 1 thing?
Yes.
Yeah.
Basically just talks about the importance of like.
Like an interview. Yeah. Yeah. So it was a online
It was via Zoom.
interview, probably long. Okay. Yeah. Okay. All right. So the reason I ask, counsel, is because the recommendation is for sobriety court, and if she doesn't have a prior, she's not eligible.
That's, I
Okay.
did talk to Mr. Muhammad about that, and you know, he was making that recommendation. I said, well, I don't know that she's.
Yeah. I think that's a parameter that he's been given from downtown, that if it's a high BAC and it's pled down,
Right.
that's a recommendation they make. What was our BAC?
Yeah.
That's all right. Take your time.
It was a 0.18.
Okay. All right. So here's what we're going to do. We're going to send you down to our probation department, set up a sentencing. Counsel, you can follow the file down and then you can have some input on when the sentencing date will be. They're also going to have you come back for an interview with one of our probation officers. Based on that interview, they're going to put together a report and recommendation to me for what they think sentence should be. Then the three of us will meet again. We'll talk about anything you want to talk about, and then I'll determine what the terms are. Understood? This on yours?
Yes.
Yeah. Cordell Scott.
Thank you, Your Honor. Attorney Josh Adley, here on behalf of Cordell Scott, standing in place for MIDC counsel, Ms. Krista Medina, with my client's permission.
Good morning, Mr. Scott.
Cordell Scott?
Thank you.
Your Honor, we have reached a resolution in this matter. The current charge of the operating while intoxicated with a BAC greater than 0.17 will be entering guilty to straight OWI.
All right. Sir, did you discuss your rights with Mr. Hadley or with Ms. Medina, some attorney? You understand the rights you have and the options they present? Understand the possible penalty for this charge? Understanding all of this, are you pleading guilty today to the added charge? Are you doing so freely and voluntarily?
Yeah.
Mr. Hadley, can you voir dire to get the facts I need? A May 4, 2024 incident date?
Mr. May 4th of 2024, were you state of Michigan, County of Wayne, city of Romulus?
Let's see that. Where was the incident at?
Oh, Michigan's going to be big.
In or about the general vicinity of this district?
I'm gonna tell you just a minute. Rossville Road 94.
There you go. Were you at Rossville Road 94, Wayne County, state of Michigan, on May 4th, 2022?
Yes.
And at that date and time, you consumed alcohol prior to driving? And was your blood alcohol content above a 0.08?
Yes.
And did you review the Michigan State Police blood test with me that showed the result over a 0.08?
Yes.
Did you have any reason to think there's any errors or any scientific reason that test was wrong?
No.
Okay, and did that alcohol that you ingested that night in any way impact your ability to drive? Your Honor, I think we've satisfied the element.
I'm satisfied as well. I'll accept the plea to the added charge, dismiss the original charge. I'm going to send you downstairs to hook up with the probation department and schedule an interview date. That you also find out when your sentencing date is. When you come back for your sentencing, you have a chance to go over the report that's prepared by probation. They're going to also recommend sentencing. You'll go over all that with whoever's here, Miss Medina. Hadley. Yeah. Yeah.
With them.
I'll look at that report and then you, the attorney, myself, will have a conversation about anything you want to talk about, and then I'll determine what the sentence should be. Do you understand all that? In the meantime, your bond is continued. Any questions? You're welcome. Downstairs, listen for your name. You as well. Christina Sidoraninos. Say it again. Sidoraninos. Good morning.
Your Honor, that's me. I'm sprinting into the court right now.
You're doing what?
That's me. I'm on my way.
You can stay there. I'm just going to adjourn it, right?
It's an arraignment on an alleged operating while intoxicated offense.
I'm assuming you'd waive formal reading and stand mute.
100%, sir.
I'm assuming you won't object if I put your client on a personal bond.
That's exactly what we were asking for, Your Honor.
And
Mind
I'm
reader.
assuming you can pick a Wednesday.
Yes, Your Honor. Let's
See
go
how
with-
easy?
Yeah,
Go ahead.
absolutely.
Fine.
What Wednesday? Not you, him.
Oh, sorry.
Your Honor, on this one, there is some blood test involved and a little bit of video. Let's go out, if we may, until. Can we go as far as June 11th?
Work for you?
Yes, perfect.
June 11th, how about 9:30?
That'll work.
June 11th, 9:30, confirmed with your client.
Phenomenal, Your Honor. Thank you.
That's
You,
going to be, that'll be on Zoom, Judge Martin,
Judge. 9 AM. Sorry.
9:30. All right. Judge Martin on Zoom.
Excellent.
All right. Now, ma'am, I'm going to put you on a personal bond with a number of conditions. First one is the obvious one, you stay out of trouble, no new crimes. Second one, equally obvious, you have to be here to participate with your court date, either virtually or live on June 11th. Thirdly, do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. Can you abide by those rules?
Yes.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess that up?
Yeah.
Any questions? Have a lovely day. We'll get you notice and get you out of here. Mr. Duncan, Erica Mazdi,
Passing that along, we've had something come up on it.
what's the next one?
I've got buddies, we don't have a file, that's what we're waiting, I think we're waiting for a file on that.
Okay,
Paula Ashton,
got that one in my hand.
I'm just, all.
Good morning.
Hey.
How are you? Good.
Judge, I'm asking for a jury trial.
Okay. We got any of those? That'll be fun. We haven't had a jury trial together in a long time. Yeah, but not fun for you. It's state. Mohammed.
Gotcha.
June 2nd.
Second judge is gonna be for that.
Okay. Where's she got you on vacation now?
No, who's gonna be? Could we go either late June or maybe early July?
July, the only thing we would have is either July 10th.
That's a good day, Joe.
Yep, July 10th. The Thursday.
All right. July 10th, 8:30.
Thank you, Joe.
Bond is continued. You're welcome.
And so my, one was Samuel Coleman. Samuel, come up, please.
Go ahead. What are we doing on Miss Coleman's file?
On the juror, I think it's the ring. If it's a ring,
You way formal?
I waived the reading and we're asking for an adjournment. Audio and video, I was wondering if May 21,
Any Wednesday.
May 21 would work.
That will be Judge Patton by Zoom. Good morning. And 9:30?
9:30. It's gonna be on Zoom. Okay. Good, so I have the other two files, but I'll come up when the overweight files is here and then I'll see what's going on. Fine.
Okay. All right, let's take care of a bond for Miss Coleman. Good candidate for personal. Ms. Coleman, I'm going to put you on a personal bond with a couple conditions. The first one is the obvious one, you stay out of trouble, no new criminal charges. Second one is also obvious, May 21 at 9:30, you got to participate on your court date. And then lastly, do not purchase, possess, or consume any mood altering substances unless you've got a doctor's prescription. Can you live with all those? Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond? Any questions? You're all set. Stick around, we'll get you a paper notice and then we'll get you out of here. Yep.
It's not with the judge. No, we haven't done that. I said there, you've been at the change. You want to?
Judge, Mr. King's ready on Roseboro Wallace.
We're not waiting for Thomas Jones's address, are we? You got that already?
Yeah, we're good.
Yeah, okay, that's what I thought.
Counsel, are you ready on Roseburg Wallace? You just thought he was ready, Michelle.
He was. Well, now I lost. Where does client go? Uh-oh. He's in the jail.
No, he wasn't in jail. He's here in person, I think. Looks like he's in jail.
Oh, really?
Oh, Russ, he is in jail. He's just here and they
I'm
brought
like,
him
I'm
here.
pretty sure he's
Yeah.
Yeah,
he's
he's
gone
Yeah,
now.
they
We lost
transported him
him.
out. They transported him here when we didn't want him.
We
Counsel, you got
lost
anything
him.
ready? With a V?
Yeah, we're all set. Thank you.
You as well.
Heather, someone needs to go find him because we lost him
Hey, Joe?
wherever he's at.
The guy, Rossboro guy.
He was on screen, he's gone.
Ask the guys out there about what happened to him.
What's his name?
It's the guy that's live in custody here on Zoom somewhere in the building.
Rosboro Wallace is his name.
What is your guys' name? Last. Emily.
Yeah, that's Murray's client. Mr. Duncan's client.
And what is your name? Cameron Harris? Did we handled you earlier?
I thought we did.
You're waiting for an adjournment notice.
Mr. King, we lost your client. You want to go talk to your other one while we're waiting?
That's fine.
Thanks.
But I can physically tell you where that guy is, I cannot
He's not on Zoom, they got.
virtually tell you.
Have a good day, sir. What do you got?
Mr. Thierno, last name So, S-O-W.
What time was he scheduled so I can find him on my list? Thank you. Go ahead and talk while I look for the phone.
Your Honor, Judge. On behalf of Mr. Jim, Thierno So.
Good morning, sir. Go ahead.
Thank you, Your Honor. We have, waive criminal grievance matter standing for range purposes as they're not guilty, they are prepared to resolve.
Go ahead. Tell me what we're doing.
Your Honor, the current misdemeanor charge of proper registration will be dismissed. We'll be pleading guilty, or I'm sorry, responsible to the civil infraction and non-abstractable offense of no registration on person.
Is that the way you want to resolve this today? I'll accept the plea to civil infraction. I'll dismiss the 90-day misdemeanor. Fines a cost $200. Can you pay that today?
Yes, I do have a bond of 150, I believe already.
You only need $50 then. Do that downstairs and we'll get you out of here.
Sure.
You're welcome.
Checking them when you're done here. Nothing else on Zoom right now.
In this intense courtroom moment, Melissa Pays stands before the judge hoping for probation. But the judge isn't convinced. After reviewing her criminal history and the seriousness of the charges, the judge delivers a cold decision. Probation is denied. The courtroom falls silent as the judge sentences her to 9 years in prison.
Judge, can we ask for a mutual order of sequestration? I also want to make a record with regard to a discovery update.
Sure. We got anybody in the courtroom that is a prospective witness?
So, yes, I was gonna also join in the mutual order of sequestration. Stacy English is gonna be the first witness, and so she's in here
Okay.
on the time.
Nobody else in here? Hold on, one at a time. No other prospective witnesses here?
Not from our side, Judge. We do have a couple of people here, but.
Okay. Then you're satisfied with the courtroom as it is?
Judge, I'm gonna ask for acceptance of the officer in charge, Dale Harris.
Granted. Granted. All right.
The only other thing with regard to sequestration is I don't know if we have a full Zoom panel on, but I did see in the previous time there was an observer for the Gilligan case who was unnamed.
I don't see anybody now.
We just don't know who might be able to.
Yeah. Yeah. Everybody right now is accounted for. All right. And then you want to say something about, what's that? Yeah. Yeah. Well, yeah, you understand we're live streaming, so I don't know who's watching YouTube.
Fair enough. I do understand. Well, hopefully they heard what you said there.
Aren't you nice? Go ahead.
Anyway, Your Honor, there is a discovery update at, yesterday evening, just before 6 o'clock. I did receive 2 new, Axon emails with links to videos. Videos are one of the issues that we've been, discussing between Mr. Muhammad and myself. Many of the videos that I received, I didn't count them all up, and frankly, didn't get time to watch them all. From what I've seen, there were mostly videos that I believe we already have, if I'm not mistaken. There were 2 videos from Officer Valevska that are new. Neither of them are the ones that we were looking for. There are 2 very short snippets that we received. The ones that we're looking for, and I was just telling Mr. Muhammad and Detective Harrison, are one where she approaches the property, Mr. Gilligan's property, walks up to the driveway and sees the pellet gun at issue resting against his Ford Bronco. She recovers it, places it in the trunk of Sergeant Stanton's car. So that's something that we're looking for, the key piece of evidence being recovered. The other one is when she returns to the English's home and picks up their completed written statements. I have video where she drops them off. I have video where she is coming back to the house at about 11:06 a.m. with the completed statements already in Miss English's handwriting. I can see in her hands. She comes to clarify a few questions and have her answer some questions that she's handwritten on the sheet. What we're missing is where she goes and actually picks up the statements from them. So we do have her under subpoena. I can ask her today about the use of her body-worn camera. Mr. Muhammad, I don't think he's disputed.
I'm stipulating, so the defense's request, I think he's entitled and should receive all the body worn cameras associated with this case. So if there's any kind of ordering sound, no, I just send the request to OIC.
Understood. Understood. So you can submit a stipulated order when it's convenient to do so.
We do have one, there's other ones too, like there was one from Officer Short.
Okay,
That missing.
but I'm holding an exam today, right? So any discovery issues you guys have, it sounds like you're going to stipulate, and if you don't, work it out downtown, because none of them are going to stop our exam today. Okay, well, if you don't go downtown, I guess it's all moot anyhow. So let's call a witness.
Thank you. The people call Miss Stacy English.
Miss English, come on up. You're all the way up front, ma'am? Yeah, watch your step on my ramp. Before you jump in that chair, raise your right hand for me. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today? Settle in. English like it sounds?
Yes.
When you're ready, Mr. Muhammad.
This English, can you please restate the name of the record and spell it?
English.
Okay, I'm gonna ask you to speak a little bit louder because these microphones have to record what's being said.
Yes, sir.
Thank you. Okay, Ms. English, I'm gonna take you back to the date of November 17th, 2024. Did something occur at or near the location of 40127 Rob Road? And for the record, that's spelled ROB Road.
That's correct.
Was that located in Van Buren Township, County of Wayne?
Yes, that's correct.
What happened at that location that drew your attention, if anything?
My neighbor got a little pointed gun at me, where he was standing on our property. So.
Okay, again, ma'am, it's very difficult to hear you, so you
Oh,
have
sir,
to
yes.
speak loudly.
Okay.
Hold on, hold on, ma'am. You can probably pull that mic a little closer to you, and then you don't have to
Thanks.
sit up, probably comfortable and pull. Go ahead.
Yes, my neighbor had me pointed on at me and was a little formal son. He was pointing into our kitchen window. At the time, he was standing on our property. So the address would be 14310 Road. But the address is his address.
Okay, and you indicated you were holding your son?
Correct.
What is the name of your son?
Theodore?
Okay, and you indicated that a gun was pointed in your direction?
Yes.
At you. And how did you feel in that moment when that gun was pointed at you?
An initial shock. However, I was slightly prepared for it because there were actions leading up to this that made me think something might happen. Including he had his branch and chainsaw over his head, within the 10 to 15 minutes before this. And he also did this gesture directly at me.
This is now the other.
Yeah, it is a little bit narrative. Let's stick to question and answer.
I'm sorry, can you repeat the question?
Yes, so I'll change the question, so. Did something happen leading up to the pointing of the gun that drew your attention?
Yes, so, yes, I was feeling. Luckily I was prepared because I remember telling my husband, if he gets a gun, we need to call 911.
Check.
Any response?
No,
Well, she testifies as to what she said. So that's okay. Go ahead.
Yes, he pointed the gun at my son and I, and initially was shocked, but then I quickly,
What actions occurred prior to the gun being pointed at you that made you feel prepared? You indicated you felt.
yes, I had already told my husband, we'll need to call 911 if he does anything crazy that it's a weapon, and he had already done this gesture too. So,
Okay, Your Honor, please let the record reflect that the witness is taking two fingers, taking it to her eyes and then pointing it away.
Yeah. Universal gesture, meaning I got eyes on you.
Yes.
All agreed? All agreed?
Yeah, I didn't see the gesture, but I.
You agree that's what that means? Okay, thank you. Okay, once again, we're getting into telling stories. Let's stick with questions and answers. You're all right.
Okay, but when he did the hand gesture, it was at your direction?
Yes, that.
Okay. And I guess my follow-up question is, again, how did you feel when that firearm was pointed in your direction?
Terrified.
Okay, and what did you do after that firearm was pointed in your direction?
So I told my husband,
I object to, I apologize for the late objection, I'm objecting to the term firearm, it has not been established that there's any firearm.
Okay, I can rephrase it.
Okay,
What was perceived as a gun, what did you do after that the alleged gun was pointed in your direction?
I took my son to our living room, which because there's a wall. So I was protect, and I was laying behind the couch, and I told my toddler to come. So I put up my head.
Okay, why were you hiding behind the couch?
She wanted to shoot us.
Oh.
Sorry.
No, it's okay. Wait.
Joe. Jackie,
And then my husband called 911 and he told
Did you
us.
tell your
he told us-
Did you tell your husband to call 911? Why did you tell him that?
But I don't think it's gonna shoot us. The roar.
Okay. The gun, can you describe it?
It was long. I tried thinking about detail, like I couldn't tell you color or anything like that. It was long. It was.
Was it a handgun? Was it
No.
a rifle, a shotgun?
I had no guns.
Okay, can you describe the length? You said it was.
It was
long.
a longer gun. That's what all that registered. One gun.
Okay, so a long gun,
Yes.
okay. Now, this individual that pointed this long gun at you when you're driving, you see this individual in the courtroom, this
Yes.
individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that person's wearing?
Yes, he is wearing a white shirt.
Can you point to that individual?
Yes, I did not know his last name until this weird.
Your Honor, please let the record reflect the witness has identified the defendant and no further questions.
noted for the record. Mr. Prain, your witness.
thank you, Your Honor. This initially afternoon, I think it's afternoon, right?
It's always afternoon somewhere.
I may have seen you here at court before, but we've never been introduced, correct?
Correct.
All right, my name is Brian, I represent Adam Gilligan in this case. Adam Gilligan is your neighbor, right?
Correct.
And his house is adjacent to yours, is that a fair description?
Yes.
The back of your house, or let's say it this way, your house is to the east of his, correct?
My house is southeast.
Right, because his house faces north, right? Your house faces east, correct? So a section of your backyard abuts to his backyard, right?
Yes.
The rearmost or the southernmost portion of his backyard, right? You moved to Rob Road when?
2020.
Okay, now, you don't really know Adam Gilligan very well, do you?
No, I do not.
In fact, you don't really know him at all or anything about his life or him as a person, correct?
Yeah.
Okay, you said before that you had one interaction with him previously, right?
I believe it was 4.
All right, you remember
Very no.
you remember speaking to the officer on November 17th?
Yes.
Okay, that was Officer Valevska. Do you recall her name?
What was her name? Is that the same officer?
It was a female officer.
It was the officer.
And you recall saying, that you only had one interaction with Mr. Gilligan before, correct?
That would not have been true, but because I have had 3 or 4.
Well, you remember saying you only had an interaction with him because his chickens got into your yard?
Yes.
Correct.
Yes.
So you said that first, and then later on you talked about a property dispute, right?
I wouldn't call it a property dispute, but sure.
Several times throughout your interactions with the officer, you complained about Gilligan, which you claimed encroaching on your property, right?
His chickens, sure, I wouldn't call it complaining, I was just, that's obviously not something I feel about this.
Several times.
But
My apologies.
that I was just letting her know that that's the only share.
All right, several times when you brought that up, right?
Okay, perhaps, I
True.
didn't recall it.
Okay, well, you do,
Okay.
even though you don't know Mr. Gilligan, you already formed some ideas about him, right? Prior to that date, correct?
Yes,
Right? Because you said that, you told the officer that you know he has a history, right?
yes.
What type of history did you know that he has?
I know that he has.
I'm talking, and I apologize, I mean, on that day, what did you know?
On that day, oh, sure, okay.
Yes.
On that day, I had known that every time officers come to his property, there's always 4 or more police officers called to his property. Everybody on our street knows that information and is alarmed every time police are called to his residence, which is frequently in the last few years.
And you'd agree that gives you an impression about him before you ever met him?
Certainly,
Okay. And in fact, what you told the officer is you know that he has a history, but you don't know what extent, right?
correct.
You know details, correct?
I didn't know the details, sure.
Okay.
I grew up on the road, I lived there since I was 2 years old. And my dad lives down the road and, Mr. Gilligan had bragged to my father how he set me responsible.
Well,
So yes, I have.
I object to that hearsay.
Oh, sorry,
Noted.
ask me, so I'm letting you know everything that I know.
Well, the fact is, people had told you negative things about Mr. Gilligan,
Yes,
correct? And you were bearing those in mind on this day, correct?
of course. Yeah,
Exactly. How could you not? Just like if I told you that we're gonna meet a friend of mine, but you should watch your purse because he's a little shady, that would color the way you see that person, correct?
sure, that was fair to
You
say.
would agree that happened with regard to Mr. Gilligan, right?
Yes,
So you said that you saw him, you claimed that he pointed a gun at you, correct?
yes.
Um,
I know he wanted to do this.
that is your claim, correct?
That is what it is.
You were home with your husband that day and your 2 children, right?
Yes.
Your children, to your knowledge, don't claim to be witnesses to this, right?
I don't know.
And your husband does not claim to be a witness to this alleged crime, correct?
See, I'm pointing the gun at
Okay.
us certainly.
In fact, you say that he was at the stove, correct?
He being the husband.
Yes.
I don't believe he was, I don't believe he was at the stove when Adam was pointing a gun at me directly. I believe he was in a different room. But I don't recall that specifically.
So if he said that to an officer, that's not how you remember it, correct?
Can you repeat what you're asking?
If he, your husband, let's identify, so your husband is Kevin, correct?
Yes,
If your husband Kevin told an officer that he was at the stove during the alleged incident and didn't see it because he was cooking, that's different than the way that you remember it, correct?
sure. Yes, yes.
By the way, you have friends and associates in law enforcement too, correct?
Objection, relevance.
What's relevant?
The relevance would be to show bias in motive, judge. If she has partiality or professional or personal relationship with anybody in law enforcement, then I think that's relevant.
Judge, that is totally inappropriate. My dad's a physician, so does that mean every question that's related to medical makes me biased? Absolutely not.
Judge, is that
We'd have to inquire about your relationship with your father.
I'm sorry?
We'd have to inquire about your relationship with your father to answer that question.
Well,
I agree it's not relevant. It assumes that just because she knows law enforcement officers, she's going to lie about an incident.
Well, not that she would lie. I'm not necessarily making that assertion.
Given the fact that she's not making allegations about a law enforcement officer, it's not relevant, so move on.
Do you know any of the officers that responded to your house on November 17th?
I didn't know, but I didn't.
Had you ever met any of them before?
No.
Do you know anybody that knows that?
No.
Do you have a brother that's a police officer?
objection, relevance.
Not relevant, move on.
You said that you only saw Mr. Gilligan for a second, right?
When?
When you claimed that he pointed, what you believe was a gun at you, you said it was only for a second,
In
right?
that moment, yes, because once it registered,
I'm not asking why, just my question is you saw him for a second, right?
yes,
And then you said you quickly took off and went to another room, right?
yes,
Okay. You told us today that he made a eye gesture, right?
that was prior to him having a gun.
That was prior, how much prior?
I'm not certain, but I would guess around 5 minutes.
Okay, would you agree that when you explained it to the officer, you stated those 2 events, pointing the gun and the eye gesture, to be at the same time?
I don't know what I don't remember this almost half a year ago. I
Okay,
don't remember.
You agree that your memory of the events in question were better, fresher on the day of the incident, right? Okay.
Mr. Prane, I hate to do this, but this is kind of a unique situation. I've got Ms. Dinsmore on camera.
I'm sorry.
Counsel, you want it? I got Dinsmore on camera. Well, I'm just gonna take a break. Are you okay to sit there, ma'am? You all right?
People have no objection to the defendant's request for the competency. Is it okay if I go get?
Yeah. Ms. Dinsmore, are you there?
Ms. Dinsmore, can you touch your screen and hit the little microphone button to unmute?
You want to just try to do it on speakerphone?
I can turn it. Well,
Yeah, I'd like to accomplish something.
hi, is this Ms. Dinsmore?
Yes, it is.
Ms. Dinsmore, this is Attorney Nancy Richards. I have you on speakerphone in front of Judge Oakley. Can you state your full name?
In a shocking courtroom moment, prosecutors describe a terrifying crash that could have ended in tragedy. According to testimony, the passenger suddenly grabbed the steering wheel while the car was moving at nearly 65 miles per hour. Witnesses say the suspect shouted, "I'll kill us both," before forcing the vehicle straight into a concrete wall. The violent impact left the courtroom stunned as the details unfolded. Prosecutors argued the act was intentional and could easily have taken lives. After hearing the evidence, the judge didn't hesitate. In a firm ruling, the judge declared there was enough evidence to move forward, binding the defendant over on all 4 serious felony charges.
This courtroom hearing reveals a dangerous night that nearly turned deadly. Police testified that Andrew Lee White blew through a red light and ignored emergency lights as officers attempted a traffic stop. Instead of pulling over, the driver allegedly sped away, reaching nearly 100 miles per hour during the pursuit. When officers finally stopped the vehicle, signs of intoxication were immediately noticed. Prosecutors argued the reckless driving could have easily killed someone. In court, and the judge reviewed the evidence and the testimony from the officer. The decision was firm. The judge ruled there was enough probable cause and ordered the case bound over on multiple serious charges.